Hey guys, it's Karalynn. Welcome back to the podcast. Today we're going to talk all about estate planning and employment law. I have Jacques Leeds with me today, who's an attorney who does employment law and estate planning. Good morning. How are you?
Hey, good morning, Carolyn. How you doing?
Good. So before we dive into all things technical, tell us a little bit about yourself and how you got to where you are now.
I'm originally from Baltimore, Maryland, and so I moved down here in 2011 to go to law school in Houston, and I just loved it, and I stayed ever since, built a life, and got married and bought a house and things, and grew a practice. So, yes, that's pretty much how we got to now.
So, out of law school, did you work for anywhere else? You start your own thing right out of law school?
As soon as I got licensed, I started my own practice.
Really? How's that been?
It's been challenging. It's been a fun challenge though. Just watching it grow and building the business. I've been licensed 11 years now, and it's been some ups and downs, some challenges, but it's going pretty good now. And I'm just really proud of how far we've come since that first year, for
Yeah.
sure.
It's really hard, especially not working for anybody else. And did you have a background in legal before you became a lawyer?
No, not at all. I always tell people it's just a lot of on the job training. I mean, because even if you work for somebody, it's still some things you have to learn. Because one of my partners worked for somebody before, and she's still learning stuff to this day. And he was practicing 30 years, and he was still learning things. So, I mean, you're still gonna learn stuff, but my learning curve has been steeper than others because I didn't work for anybody, but I have been lucky to have colleagues that would help me out with different pointers and different things like that. So.
Well, and sometimes it's a good thing. It's like I worked for my professor for 2 years right out of law school before I started my own, and it's kind of been good in some ways because I'm not locked into a certain way of thinking of how something should run, and you can
Hmm.
really create your own, which is
Hmm.
which is fun, I think.
And I've seen, to piggyback on that, what's funny is I've seen people, and not say my partner, just people in general that have worked for somebody and they've learned bad habits, and then they had to, when they got out there, they figured that they learned that they were, had bad habits, and they had to like relearn some things to develop good habits. So sometimes, people always think it's a good thing, but sometimes it can be not good if you're not learning the proper way how to do
Well,
things.
and everybody's different too. Like I'm kind of leery when I have lots of attorneys with lots and lots of experience. Would they be open to my different ways of running things?
Right, 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 right.
How many attorneys do you have working for you?
So right now I have the setup is like I have an associate, I have a partner, and then I have three people that I work with like on an as needed basis, like a of counsel type of thing.
Okay,
So that's kind of how it's set up right now.
good, good. So tell me, like we talk about estate planning. What is that? What does estate planning mean?
So estate planning is basically what will happen to your estate, which is your assets and things, when you pass. And I always like to tell people, whether you know it or not, everybody has an estate plan, right? Whether you don't make one for yourself, the state of Texas has one for you. Okay, so
Mhm.
you have an estate plan, whether you actively have done it or not. And what I like to try to do is I like to try to empower people to take control of their estate plan because, um, you know, even if a lot of people think you have to have a lot of money and things like that. That's not necessarily the case. It's just, um, you know, looking out for your family when you're gone and making things easier on them. Because we get a lot of cases from people who are in their 30s to 50s, right? And their parent has just passed, and their parent didn't have a will or anything, and so now they're scrambling, have to, what do I do? How do I do this? And then those people usually are the ones that say, you know what, I don't want my kids or my wife to have to go through this, so let me go ahead and get my own estate plan. So that's how we get a lot of people. But I try to educate people so that they're not in that position where they're just leaving their loved ones scrambling, because it's really, you don't know because you've passed, but like it really, you can really feel the stress that it puts on people because they really don't know what to do, and it's just kind of like they just, everything's turned around, and then they're already dealing on top of dealing with your loss, right? And so now they got to deal with all these other things. So it's really, I hate to do it sometimes, but you have to make people have action. It's really selfish if you don't have an estate plan, to be honest with you, because you're just, you're just thinking, hey, once I'm gone, they'll deal with it. But it really is a little bit selfish because it puts your family in a place where they're dealing with guilt and grieving behind you, and also having to take care of your mess. So that's
So
fun.
what are some of the different tools that you can use to alleviate that mess?
Well, the one that I always like to try to, I guess, educate and push people towards is the trust. That's the best one, because a trust, when you have a trust, you can put everything in there. And you can also, a lot of people don't notice, you can also have a will that's inside of your trust, right? So the trust is the best one because it avoids having to go through probate when you pass. And it's the most cost effective. You can put you can put everything you want done in the trust. You can put your house, bank accounts, car, you can put anything in there, and it just makes things a lot easier. So I always like the trust. It is a little more costly, but on the back end, it'll save your loved ones and your estate money on the back end. So it becomes cheaper when you actually do pass. But I always like, the trust. A will is fine. That's fine too as a backup, and then. But you really want to have that trust, especially if you like own a house and things like that. The trust is
So tell
kind
me
of.
more about the trust. So like when you set up a trust when you're living, do you like title all the assets in the trust name? How does that work?
Yeah, so it's a process called funding. So a lot of people they figure that they can do it DIY, right? And so they'll go to these rocket lawyer and everything. And not a knock on those people that do the forms, but what happens a lot of times, Carolyn, is they'll have these documents that they've done, right? And the documents are valid, but they haven't done the crucial second step, which is called funding, right? And a lot of people, lay people, usually don't know what that means because they're thinking funding, money, whatever. But funding is actually, like you said, you have to deed and transfer the items actually into the trust. So you can create a trust, but it's not valid if you don't fund it, which is transferring the property and things actually into the trust and putting it in the trust name.
So say I have a house that has a mortgage on it. Could I still transfer it to a trust?
Yes, definitely, absolutely,
Okay. And so then
absolutely.
are trusts recorded someplace, or how does somebody know that I have a trust?
Well, so the trust, as your attorney, we would have a copy of it, and then we provide you with a copy of it, and then it's on you to. We always like to, suggest that give the beneficiaries a copy of the trust, so they can have it. So we always make sure that we have a copy, and we'll keep a copy. You get a copy, and then we give if the trustee, if it's different from you, and the beneficiaries a copy to make other people aware that the beneficiaries at least will know that there's a trust, because they usually get a copy.
Okay. So I have a trust. I have all my assets in there. I pass away. Then what happens?
Okay, so then what happens is once you pass, the trustee will just carry out your wishes as it's laid out in the trust, and the things will automatically transfer to your beneficiaries as it's laid out. So you don't have to go through any court proceedings, and it's private too. So it's not, when you have a will, you have to probate that will, and then anybody, your nosy neighbor next door can look and see, oh, what did Johnny have, and who did it go to? With a trust, it's all private. No one can see how your things got passed. And you just avoid a lot of costly things like the executive fees, the court fees, different taxes and things like that. So, the trust really is the way to go to
And
me.
so life insurance is usually paid to a beneficiary. So that wouldn't be in the trust either.
Well, so life insurance, you can put it in there. And because sometimes with life insurance, they'll have some policies where you can like build value and borrow against. So you can put it in there, and while you're living, if you need to like use, some of that equity, you can put it in there. But then it's just gonna pass, according to the policy to the beneficiary. But you can put a life insurance in there, yeah.
So in this, like I put my house in the trust, I pass away, I have a beneficiary listed, and then the trust writes a deed to the beneficiary.
Right, right,
Okay.
right,
So
right.
that's allowable under the trust.
Mm-hmm. Mm-hmm.
And a will does all that stuff just publicly.
Right. And so, and then the will, you actually have to, go through the probate process, which you have to hire a probate attorney to probate your will. Then you have to go through the part of proving up your will. So they have to prove that the will was valid, right? They have to prove it wasn't forgery or, he had Alzheimer's and somebody did this to try to get the, so you have to go through that. And then it has to be publicly known in case anyone wants to contest it or things like that. So, yeah, and then you have to pay the court fees and things like that.
It probably
With the
takes them a lot
will,
longer too, because I know the court.
yes, yes, it definitely takes a lot longer, especially if there are conflicts amongst family members. Which a lot of people think that, oh no, it won't happen like that, but you'd be surprised how many conflicts arise when people pass away and they're fighting over assets and things like that. Like people will never think it's going to be their family, but Karalynn, you will be very surprised. People really, when people pass away and they feel like it's some money to gain, yeah, it gets real interesting to say the least.
Can people contest the trust?
No, no,
Okay.
because it doesn't it doesn't require you to do the things that you have to do with a will, right?
Okay. So it's basically like
So
a contract, or
what you say?
it's like a contract. Like I'm just trying to understand how nobody
It's
can.
it's its own legal entity,
Okay.
right? So it's like a person, but it holds all your assets. So it's like a holding. It's like another entity that you've created. So it's not a contract.
Gotcha.
It's like another legal entity, like almost maybe like an LLC, like how an LLC is not you, but you may own it.
Hmm.
It's kind of like that.
Gotcha. Gotcha. What about like, so we kind of went over will, you can do all that, how you leave things, it's got to go through probate, be approved, all that. What about like end of life planning, like paying for the funeral, that
Yes.
kind of stuff? What do you do
Yeah,
for that?
yeah, those can all be that can be laid out in the will or a trust, really. But like I said, if you have some people that they've been told will, so we can put a will inside of a trust. That's not an issue. But those can be all in your directives. Your funeral, who's gonna pay for the funeral. I mean, you can, Karalynn, even down to like what you want to wear. Really, like hey, put me in my leopard print. I like my leopard print. I always look good in it. Put me in that. Okay, we got you. Everything down to a T that you can think of can be drafted as a directive and put in there.
Awesome. Uh, awesome. Is there any other documents you can think of that would be important for estate planning? If you have the trust, you really don't need anything else.
No, you don't really need anything else because you can put it in there. But I've had some people that they might not have like a lot of assets and like they only have a house. And so sometimes for people that are like, because when you do the trust, you do want to have like the most people that have a trust, they have like a house, they have cars, they have different type of accounts, retirement accounts, IRAs, things like that. They have stock trading accounts. They have some stuff, but what we sometimes do for people, and a lot of people aren't aware of it, but if you just have a house and that's all you have, you can do a ladybird deed, which
Mhm.
basically is that, hey, all I have is this house, and upon my death, this house is deeded and it'll be transferred to my kids, XYZ. You can name those people. And so, if somebody really can't afford to do the trust and isn't really interested in doing the will, they can just do the ladybird deed, and that way their house just gets passed, and that's pretty much all they have. So
What about a business? Like, would you put your law firm in a trust?
you can. I mean, you can. I'm working on something like that now because my wife and I practice, and initially it was just me, so I'm trying to work the kinks out as to doing that. But yeah, that's something that we're working on right now. You can put a business in a trust, sure.
With to sell it, or instructions on how to run it, or either or?
All that, all that. That's why I say it's the best thing because it's really it's really like I tell people, it's like a blank canvas, and it's just like however you want, whatever you want to put in here, you can put in here. You just have to fund it, get everything titled and deeded properly, and it can be in there. So that's actually something we're working on now, and we're trying to work out how to do that now.
A law firm would be interesting because it's got to be owned by a lawyer. I guess if the
Right,
trust is owned by a lawyer.
right. But yeah, you can put businesses in there. You can put anything in there, really. Anything you can think of, you can put in there.
Now, when you do a trust or a will, is it normally a flat fee? Is it hourly? What does the charges normally look like?
So for us, and our prices are pretty much competitive. So for a single person, the trust is like 4,000. If you're married, it's 5,000. Now, if it's a more complex trust, like if you just have like a lot of houses, a lot of property, just something, that you're just way above the normal, it might be an extra 2,000. And we kind of weigh that out. We give everyone an intake questionnaire that's interested to fill out, and then we kind of go over it, and it's just like it rarely happens. I mean, these are people that have like 10 properties, right? It's just a lot of things we're gonna have to deed into it. But the typical cost is 4,000 for a single person, 5,000 if you're married, and it will cover both spouses. And we can even do, and people, this is a common question we get. So what if we get divorced? Can we kind of already pre-put in there how things will work if I get divorced or my husband does it? We can do that. Yeah, it can be done. So that's why I always say people to do the trust. Now, a simple will it can be like 500. Wills are typically like 500 to like 750. At the higher end, like 1,000, but it's really going to be about $500 for a
But
will.
usually it's on a flat fee. It's not something that's charged hourly.
It's a flat fee usually. It's flat fee. Now, the only time you get into hourly is when it's like you got to do some probate work.
Yeah.
That's when it gets to hourly. But the wills and the trust are flat fees usually.
What about medical directives? Is that something you do at this point too? Do you put that in
Yes,
the trust, or where does that
yes, yes. You can put that in the trust as
go?
well.
Gotcha.
Uh-huh.
That's all interesting. Very good to know. Okay, let's switch gears. Let's go to employment law. Do you normally represent employees or employers?
For the most part, employees, I'd say our mix has been about 90% employees and maybe 10% employers. So it's overwhelmingly we represent plaintiffs usually.
So I'm always curious, like in Texas, a right to work state, how can you have a wrongful termination?
So with wrongful terminations, that's a good question. They're based, or you have to base it on some sort of discrimination or disparate treatment based upon the EEOC's protected classes. And the EEOC's protected classes are race, gender, religion, national origin, disability, pregnancy, color, sexual orientation is now one that's been added like a couple years ago. Retaliation. I think I got them. I always go down the checklist with clients, but I think that's pretty much it. And so retaliation, what a lot of people think is retaliation is not under the EEOC. So a lot of people think retaliation is like, well, I asked to take lunch an hour early and, they said no and then they fired me. That's not retaliation, right? Retaliation still has to be based on one of the protected classes. So it has to be, let's say, um, let's say someone had to go and get a surgery, right? And let's say they were asking for accommodations for their surgery. And so let's say that it's another person that doesn't have accommodations, right? And so let's say that person, after they've asked for the accommodations, is now feels like they're getting their work more scrutinized than someone else without accommodations. If they complain to the employer and say, hey, I feel like you're treating me differently because I asked for accommodations and this person didn't, and they fire you within 3 months of that time, that's retaliation. So you have to actually, for retaliation, you have to actually complain about your inclusion in a protected class and then get fired within 3 months of that time, because that's the temporal proximity for it to
Gotcha.
be a good retaliation case.
So do all those cases start out with a claim file with the EEOC?
No, not all of them. So typically what we do is, and we take these matters on straight contingency. And
Okay.
I say that because not all employment lawyers do that, right?
Yeah, correct.
A lot of employment lawyers, and we used to do this too, but we stopped. But a lot of employment lawyers will do like a hybrid thing, right? They'll charge you a retainer, and then they'll have a contingency interest in the case. And then if the case settles, this is like a 50-50 split on employment lawyers too. If the case settles, some credit the initial retainer you paid to their attorney's fees that they get from the case,
Gotcha.
some don't. And so what we stopped doing it just because employment can be, and we never did this, but one, I stopped doing it because I stopped taking advanced retainers because I was the type of person that I credited it to my attorney's fees in the end. And so just for bookkeeping purposes in my books, I stopped doing it because it was kind of a hassle, right?
Mhm.
So I just take them on straight contingency. But I take them on straight contingency. Now with me doing that, I have to be a lot more stringent on the cases that I take. I have to do a lot more work on the front end to make sure that it's actually a good case. To make sure that it's that, we're going to get something on the back end. And, I feel like employment can be tricky because there's a lot of, I don't want to say a lot, there's a good number of attorneys out here that will tell clients what they want to hear, right?
Yeah.
Because you got this person that's been terminated. They're feeling like they've just been done wrong, right? And so they'll tell them what they want to hear. They'll charge them this $5,000-$10,000 retainer, knowing that they really don't have anything. And then the client is upset and they get mad at the end because, they didn't have a case to begin with.
Mhm.
And now it's just, I don't think that's a good situation for the client or the attorney,
I
because
agree.
now you got somebody who's feeling like, oh, this guy he just scammed me, right? And he got
Yeah.
my money and I didn't get anything out the bargain. So we do it on contingency for that reason as well. So it's like, we're in it with you. And we're not just gonna take something to tell you what you want to hear. So you pay us this money and then you really don't have anything. But there are some attorneys that do that. And that's their practice. I'm not gonna say it's right or wrong, but it's just it gets a little tricky
Mhm.
sometimes.
So what are the cases then somebody has to file an EEOC claim with the EEOC
Oh,
commission?
sorry, I didn't answer your question. Sorry. Let me go back. We don't always start off with an EEOC filing because our process is we like to send a demand letter first to the company to see if they want to engage before we have to go to the EEOC. And if they don't want to engage, that's when we file with the EEOC, and then we take it from there. So
Gotcha.
yeah.
Gotcha. So what other kind of employment claims are there besides wrongful termination that you deal with?
Overtime, so unpaid overtime, FLSA claims, class action claims like that. So we're actually it's we actually have a really interesting one right now, Karalynn. I mean, we're defending it, but we're defending a strip club, right? There's a class of, there's a class of strippers that are like, hey, you guys didn't do, because it's a
I'm
thing
not a
called
1099. I should be a W-2.
that, and it's a thing of tip pooling, right? So like you can tip pool, but you have to do it the proper way. And so if you're not doing it properly, that's where you can get in hot water, and that's kind of a hot topic going on right now with strip clubs. Like a lot more of these cases are popping up because of them not properly tip pooling. So yeah, that's like an interesting trend right now in overtime.
Hmm.
Strippers suing strip clubs for unpaid wages and tip pool violations. Yeah, yeah.
Well, what we usually deal with is people that are classified incorrectly, right? Especially in
Mm-hmm.
the construction industry. If you
Mm-hmm.
have somebody showing up every day at your job site doing only your work and you give them a 1099, right? And
Right.
they're trying to get out of overtime. They're trying to get out of all that stuff.
Right.
Do you deal with any of those kind of claims where somebody was
Yeah.
classified?
Yes, all the time. But you know, it's funny because like the construction industry, they've gotten a little better at that because they were getting hit a lot. And I know a firm that hit like a big case. And so they've gotten better. And we've had cases like with like cable companies and their techs and stuff. And so those companies, after a while, they wise up. But the interesting and funny thing is, and I know you probably know this, Carolyn, a lot of times those companies, it's so much cheaper for them and they're so much more profitable by doing it the wrong way
Mm,
that we've known companies to be like, it's just so much cheap. We just make so much more money doing it the wrong way that if we get caught, we'll pay. And then like, we had a company that was just like, it's like a thing. Each time you get caught, the penalties get stiffer. And so if you get caught 3 times, it's like really bad. So they did it up to the third time and then they finally was like, okay, now it's getting to the point where we'll just do it right. But they were just making so much more money doing it the wrong way that they really chose to do it that way because it was just so much more profitable. And it's like, you're just waiting for them to get hit because it's going to happen. But some companies just operate that way.
Yeah, and then you're dealing with the Department of Labor and
Right,
the
right,
federal lawsuit they can open up and ask for all
right,
your employees for the last
right,
10 years.
right. That's why those people, they hurry up and settle. To try
Yeah,
to
they tried to. Well, and the thing is, if somebody's onto a case like that and they've already filed a federal lawsuit, they're not going to settle. They're not going to
right,
settle till the class is done.
right,
So
right.
they've seen all the books and invited everybody they could possibly invite. I know.
The interesting part about those overtime cases though is your name plaintiff and the representative of the class. It's always just a gamble because like you could get somebody that's like so good and then you can get somebody that's like so bad, and it's just like it's always you just never know who you're gonna get. Like one time we had a situation where a guy was like he was like from back lack of a better term, he was a mechanic, right? And so we thought, oh man, like what's this? How's he gonna be? That guy was so smart. Like he was so sharp, and like the defense attorney, he was like a really good defense attorney. Like he's known for like just ripping up because he asks all the questions like, well, could you hire and fire people? He goes down all the
Checklist.
the technical stuff. But like this guy, he was so sharp and he was on it, and he like could answer everything right, and the case was good. So you just never know how though that class representative and the name plaintiff is going to be. But when they're good, it can be good, but when they're bad, it can be bad. So that's always interesting too about those cases.
Do you handle like employee injuries or anything like that?
Not really, because that's where it gets a little tricky. Because I kind of most of the time I see those people are they have workers comp, and so
Mhm.
if they have workers comp, you gotta go through workers comp. If not, if they're a non-subscriber, then you can do something. I usually
Yeah.
refer those cases out, but what we do is it's a nuanced case that I don't know if a lot of people are aware of it. There's an employment claim named workers comp retaliation, right? And so what it is if someone gets hurt on a job and they make a good faith effort in trying to file for workers comp, or they actually file for workers comp, and then the company terminates them within 3 months, they're on the hook for Texas has a claim in some other states, but Texas has a claim called workers compensation retaliation. If you retaliate against a worker who files or tries to file a workers comp claim within 3 months, it's a case. And I tell you, every one of those cases we've taken has settled. Every single one. Every single one of those. And pregnancy and disability are good cases too, because it's kind of like those 3 cases are always good because they're facts that really aren't disputed, because it's usually, hey, does this person have a disability? Yes. Like, did you fire them within this time frame? Yes. Like, and it's the same thing. Did they get hurt on the job? Yes. Did they try to file workers comp? Yes. Are they pregnant? Yes, they're pregnant. Did they get terminated in this time frame? Yes. So those are like my favorite plaintiff employment cases: workers comp retaliation, pregnancy and disability. And like my least favorite, of course, is race. I mean, I don't really like race cases because the only ones we take is when it's obvious, right?
Yeah.
It's like we had one where somebody was called a porch monkey. It's like, okay, yeah, and then they were terminated. And then we had one where somebody was called Aunt Jemima. It's like, okay, but the vast majority of them, it's like, okay, they did it because of my race. I'm like, okay, well, you know, what do you have proving that? What did they say? What do you have emails, texts? No, I can just tell. It's like, yeah, we can't go to the judge like, hey, judge, it's race. We can just tell. And so those are really like my ones that race ones are my least favorite because everybody just tries to say it, and it's like, no, they that wasn't it. But you know,
So back to your, so like you terminate somebody within 3 months. What if you terminate them like on the fourth month? Is it still a claim or just not as good as?
you can still go forward with the claim. You can still go forward with the claim. It's just you now you turn it into more of a disability thing, right? So you turn into you perceive them to be disabled or they were disabled, but trust me, a lot of these companies, they're smart. Like FMLA claims are good too, right? Because it's that same 3 month. The court likes a 3 month temporal proximity period for employment for some reason, but that's what the case law is.
Mhm.
So with FMLA claims, they have to hold your job for a certain amount of time, like 12 weeks, right? And these companies, they know, like after the 12th week, like that 13th week, if you're not back working, they can let you go, and they know they can get away with it because they know that it's a 12-week period that they have to wait, and then if you're still not back to work, they can let you go with no repercussions. So you can still move forward with claims, but then it just turns on like now you're just going into like a disability or a perceived disability type of thing.
Gotcha. All right. So if somebody wanted to find out something more about your firm or all the things that you do, where should they go?
Well, they should go to our website, which is www.jleedslawfirm.com. So it's JLEEDS lawfirm.com.
I'm gonna put
And
in the show notes as
that
well.
kind of lays it out for us. And then, they could just give us a call from there and we can see if we can help them.
You're the kind of company that answers the phone.
Oh yeah, we have a dedicated intake person, and then we have a backup who's a case manager, but she'll answer the phones. We can't get it, and then we have an answering service if the two of them can't get it. So somebody's gonna answer the phone if they call in. But what's tough is that the tough thing, Karalynn, is that like with employment cases, people these days they're not used to being told no, right? And so and it's hard because I tell them, if you had a case, I'd be more than glad because I'm not going to miss money for myself. But if I'm telling you don't have a case, you really don't have a case because I don't practice, and that's why I always tell people you have to be leery. If I'm telling you no, and then you run to somebody who's telling you, yeah, you have something, but they're charging us 10,000, you got to really think about it before you do it
Yeah.
because you really might not have anything. And I know that might hurt your feelings. You don't like hearing no, but you don't have a case. So 90% of the people, I'll be honest with you, probably 90% of the people who call in for employment, we're not able to help them for different reasons. Whether some people still call in when they're still employed, we don't take those. And then people call in a lot of times we don't take government cases either. So it's a stringent kind of filtering out process we have, but we do that because the case that we do take, 99% of the time we're selling and we're getting you money.
Yeah.
So it just has to be like that. So
No, no, for both parties. You don't want to get
right,
somebody's hopes up and then it turns into nothing. So
right. So
awesome. Well, thank you
yeah.
for taking the time to be on the show.
Oh yeah, thank you. I really enjoyed it.